Good evening, loungers. I hope everybody is doing as great as I am today. Listen, guys, we have a quick pop up today because of the new things that have come out in regards to the JayZ situation next to Jane Doe. Okay. And so most people know that there is a woman who is accusing both Diddy and JayZ of R-wording her in 2000 at a party that was after the MTV Music Awards, okay? And there's been some speculation on whether, those dates are correct or what's actually going on with that. But we're definitely going to go over the new things that have come up today in regards to this matter. Make sure you guys hit the like button on the way in. I do appreciate everybody that catches the replays. And let's go ahead and get into this hot topic now, guys. I'll tell you guys, this is one of the most fascinating cases that I've ever seen in my entire life. I have watched a lot of true crime cases, a lot of court cases and so forth. And this one is very fascinating just based off of how the attorneys are moving and the things that they're wanting, the things that they're requesting and so forth and so on. But one of the things that I've noticed about this judge is that she seems to be very, very fair. And I think she also wants to be very careful in what she dismisses, or what she allows, just based off of the other victims that have come forth speaking as Jane Doe's and John Doe's in this situation against Diddy. I feel like, once, she starts dismissing things and, making things and making light of things, that would then turn away other victims who actually are victims in this situation. So let's go ahead and take a look today at Pacer. Let me go ahead and present my screen to you guys. Again, make sure you guys are hitting the like button. Hey, Redbone, I appreciate you being in the building. And everybody that's in the clouds as well. Let me go ahead and present my screen to you guys. Bear with me just a moment, because we're going to go ahead and take a look first at Rule 12B1. And the reason I want to share that with you guys is because this is what JayZ has been using, along with Alex Shapiro, to fight against this matter, okay? So Rule 12B1 would be the motion to dismiss for lack of jurisdiction, or a motion to dismiss filed pursuant to Rule 12B1 of the Federal Rules of Civil Procedure, which would allow a party to challenge the subject matter to jurisdiction of a district court to hear a case, okay? So they were basically throwing everything they could against the wall just to try to make things stick, in order for this case to go away. They've used everything from the NBC situation to trying to make it as if there are previous people that had been represented by Buzbee that they don't fool with, and that they've had a problem with Buzbee and so forth and so on. There's been so many different things that they've tried to throw against the wall that kind of just seems to not really be going, okay? And now we're going to go ahead and take a look at what the judge decided in regards to this. Okay, so let me go ahead and share this with you guys. So if you guys can see that, that's great. Hey, Carla Martin, I appreciate you being in the building as well. And again, everybody that's in the clouds, let me go ahead and make that a little bit bigger for you guys so you guys can see. Again, this is the case number. Go ahead and get yourself a Pacer account and check out that case number, okay? It will show up as Sean Carter versus Jane Doe, okay? Now, it was filed today on December 26, 2024, and it's about 5 pages long, and this all comes from the judge in this case, okay? So it is the United States District Court, Southern District of New York, Jane Doe plaintiff against Sean Combs, Daddy's House recordings, all these other names, and all the way at the bottom, along with individual does 1 through 10, and Sean Carter, okay? Now, this is Annalise Torres, which is the district judge that's in this matter. And again, this was filed today on the 26th, okay? And the order is as follows. Plaintiff Jane Doe filed this action on October 20th, 2024, alleging violation of the New York City Victims of Gender Motivated Violence Protection Act, NYC Admin Code 10-1101, and see generally EFC number 1. So what you can do is you can go back to this page here, and I'll show you guys what that page is. Bear with me just a moment. One moment. Okay, so here is where you can run a query on this actual case, and you can see every single entry that was entered here. So far, there have been 53 entries that have put in on this case. That would include all of the John Does and Jane Does against Diddy and so forth and so on, okay? And now we are down to the Sean Carter case, which is also being represented within here, okay? So let's go ahead and go back to this page here where District Judge Torres has ruled on this matter. So by order dated November 6, 2024, the court provisionally granted plaintiff's motion to proceed anonymously, explaining that defendants had yet to appear in this matter and that the balance of interest weighing for or against anonymity may shift as her suit continues, okay? And that was for EFC number 28. So let's go ahead and go there real quick. We'll just take a look real quick at that. Like I said, there have been multiple entries here, but this is the one that she's talking about on the order on motion for miscellaneous relief, which is number 28, okay? All right, so let's go ahead and view this again. On December 8th, 2024, plaintiff amended her complaint to add Sean Carter, known professionally as JayZ, as a defendant. And then you can see EFC 29, and that would be here on this page right here, where the amended complaint came out on December 8th, 2024, and that is the number, okay? And it says, now plaintiff again sought leave to proceed anonymously, and that was on number 32. You can go back to that page if you want to. But this time, Carter's counsel appeared and moved to deny her motion, or in the alternative, to dismiss her amended complaint pursuant to Federal Rule of Civil Procedure 12B1, okay? And we just looked at that, where it was basically a motion to dismiss for lack of jurisdiction, a motion to dismiss filed to pursuant Rule 12B, which would allow a party or parties to challenge the subject matter jurisdiction of the district court to actually hear this case, okay? So not only were they saying that this woman was lying, but they were also saying that this particular court doesn't even have jurisdiction over this, okay? So they were trying to get this removed just based off of that, okay? Now, let's go ahead and keep going. So as we know that they did try to appear and deny that motion in an alternative to dismiss her amended complaint pursuant to the Federal Rule of Civil Procedure 12B1. And those are in EFC numbers 36, 37, and 40. Carter also moved for an expedited hearing on this issue, which was EFC number 41. And then the next day, Carter's attorney also filed a letter containing a declaration from an associate at his law firm recounting a phone conversation that she allegedly, and I'm putting allegedly in here, that she allegedly had with an unnamed woman who claimed that plaintiff's counsel encouraged her to lie about her experience of S assault. Okay. And that is in EF numbers 42 and 42-1. And we did go over those the other day, where this woman who claims to work for Alex Spiro's office had allegedly received some phone call suddenly in the afternoon, in the evening, after he did this crazy rant with, with all these news, people, about him and JayZ not really being friends and all these other things. Suddenly they got this phone call from this woman who wanted to remain, quote unquote, anonymous, right? And she had all this stuff to say about Buzbee and all this stuff to say that they were lying and they were trying to make her lie. Okay. So that was in the evidence of number 40, 42 and 42-1. Now, Carter's lawyer asked the court to consider this quote unquote additional information in connection with plaintiff's motion to proceed anonymously. EFC number 42. So you can go back to that one and check that out. And plaintiff's counsel denied Carter's allegations against him. Okay. EFC number 44. On December 13th, 2024, Carter's attorney filed an additional letter alerting the court to a recently published interview of plaintiff on NBC News, okay? And this was EFC number 46 and 46-1. And I think most people are aware of the interview that took place with Jane Doe on NBC, where a lot of people are calling this a hit piece. Some people are agreeing with NBC on this, but there's quite a bit of people that are looking at them very side-eyed, including myself, right? Considering the fact of many things. One thing is that the woman is autistic or claims to be autistic. Number two, an S assault victim generally may not understand or remember every single date or every single detail of what actually happened to them. So, it's kind of difficult to just gauge that based off of that. And thirdly, we never heard from the actual father. We only heard what NBC told us that this father said, and we only heard bits and pieces of this conversation that NBC had with the alleged victim. Okay, so it's quite difficult, with using critical thinking skills to kind of just believe NBC on this situation. Of course, there are people that are always going to believe a company like NBC or CNN or somebody like that, as opposed to using critical thinking skills and understanding that the news sometimes, especially in these days, this day and age, sometimes they have their own agenda and they have very good reason to lie to the people, about things. So I think those are things to take into consideration, even though I think the mass majority of people don't really do that, right? A lot of people do put their heads in the sand and they don't necessarily want to look at the actual truth in regards to a matter. But either way, let's go ahead and go forward with what they were saying. Now, again, it says, in the interview, plaintiff speaking anonymously explained her allegations against defendant and her reasons for coming forward. And then you can see generally EFC number 46-1 for that. Carter's lawyer points to the interview in which plaintiff admitted to inconsistencies in her story as evidence that plaintiff claims to have no factual basis whatsoever. Even though, guys, I want to make it very clear that if you listen to the interview itself, she never fully said, I do have inconsistencies in this matter. What she said was, I have my flaws, right? But she didn't say, I'm inconsistent in this, and these are the inconsistencies that I've told. That's never been said. Only NBC said that there were inconsistencies in the matter, okay? But they never showed us the actual inconsistencies in the story. Okay. Now, other than what they wanted to put out later or what they wanted to say later, which of course would look like an inconsistency, if it's a different story than based off of what she said. And again, we don't know the full story of what she said because we never heard it. Now, as other than what we have in these court records. Now, as evidence that plaintiff's claims have no factual basis whatsoever. Okay. So they wanted us to think that these were inconsistent based off of this and saying that there was no factual basis to this because there were quote unquote inconsistencies, okay? And that's at 46-2. Now, he also argues that plaintiff's counsel violated federal rule of civil procedure 11B by failing to undertake a reasonable inquiry into the facts before filing the complaint, okay? Now, as we looked over the other day, Rule 11B talks about how an attorney will need to actually sign off on paperwork to prove that they have, vetted this information, that they believe this information to be true, and that they're presenting this to the court, in a way that they say this is true. Okay. If they don't actually sign off on it, then, that opens the door to frivolous lawsuits. And this is what they're trying to say. And they're fighting this off of 11B. By failing to undertake a reasonable inquiry into the facts before filing the complaint, and failing to seek admission pro hac vice to the court, which we ID'd the other day, as where attorneys will go and request to be able to practice in that court and protect their plaintiff, or protect their to be counsel for their client in regards to that court, even though generally they don't usually practice in that court. They're usually practicing within a certain state, but they can ask for pro hac vice in order to practice in another court. Now, Carter's attorney requested an expedited briefing schedule for a motion to strike the first amended complaint under Federal Rules Civil Procedure 11C2 and 12F. Okay, and we've already figured out what those rules are. The next day, Carter's counsel submitted yet another filing, a motion for an emergency order directing the preservation of evidence and striking the amended complaint under Rule 12F. Okay, now we talked about what the preservation of evidence would be, where that there would be no evidence destroyed in this matter, and that this is protected by the court. Okay, but then we're talking about the Rule 12, where they're talking about to just go ahead and dismiss this altogether, because this court doesn't even have jurisdiction, basically. Okay, and those are in 47 and 49. Now, number one, the motion to proceed anonymously. In deciding whether a plaintiff may proceed anonymously, courts balance the plaintiff's interest in anonymity against both the public interest in disclosure and any prejudice to the defendant. Sealed plaintiff versus sealed defendant, and this is the case law for that. The Second Circuit has laid out a non-exhaustive list of factors to be considered. And these are, number one, whether the litigation involves matters that are highly sensitive and of a personal nature. Number two, whether identification poses a risk of retaliatory physical or mental harm to the party seeking to proceed anonymously, or even more critically, to innocent non-parties. Number three, whether identification presents other harms and the likely severity of those harms, including whether the injury litigated against would be incurred as a result of the disclosure of the plaintiff's identity. Number four, whether the plaintiff is particularly vulnerable to the possible harms of the disclosure, particularly in light of her age, and they're saying her, in this case, age. Five, whether the suit is challenging the actions of the government or that of private parties. Number six, whether the defendant is prejudiced by allowing the plaintiff to press her claims anonymously, whether the nature of the prejudice, if any, differs at any particular stage of the litigation, and whether any prejudice can be mitigated by the district court. Number seven, whether the plaintiff's identity has thus far been kept confidential. And number eight, whether the public's interest in the litigation is furthered by requiring the plaintiff to disclose her identity. Now, before we go on a little bit further, I will say that we talked about a couple of these things the other day. One of them being, whether the identification would pose a risk of retaliatory physical or mental harm to the party seeking to proceed anonymously, or even more critically, to innocent non-parties, okay? So in this particular situation, we know that we have some very powerful people, some people that deal with very powerful people, and it would obviously be a risk to physical harm, mental harm, and so forth if this person would come out, with their identity. Also, Buzbee has been clearly putting out evidence of such things in the Texas courts in Harris County, where there have been people that, he alleges were previous clients of his that have been already approached by JayZ's camp, trying to get things to change, trying to get them to say certain things, offering money to them, and so forth and so on. So it wouldn't be very far-fetched for this person to say, hey, my physical and mental harm is at stake here if you guys tell them who I am, okay, in this particular case. So that's just one of them that we talked about. But this judge actually listed 8 various things for why this would be considered, okay? Actually, she said 10. So let's go on to the 9th and the 10th one. Number 9, whether because of the purely legal nature of this issue presented or otherwise, there is an atypically weak public interest in knowing the litigants' identities. And number 10, whether there are any alternative mechanisms for protecting the confidentiality of the plaintiff. So she actually listed 10 different reasons for why the judge might actually consider this, okay, that the plaintiff could remain anonymous in this case. Now, ID at 190, cleaned up, citations omitted. A court is not required to list each of the factors or use any particular formation as long as it is clear that the court balanced the interests at stake in the reaching its conclusion. Okay, so basically she's saying, I don't owe y'all an explanation about why I'm going to come to this conclusion. Okay, but I'm giving you the reasons why the law gives me to, within the law to make such a decision. Okay. Now she says, here the weight of the factors tip in favor of allowing plaintiff to remain anonymous, at least for this stage of the litigation. Factors 1, 2, 4, and 7 weigh strongly in favor of anonymity. Okay. So let's go ahead and take a look at those. Factors 1, 2, 4, what'd she say? 1, 2, 4, and 7. So 1 is whether the litigation involves matters that are highly sensitive and of personal nature. Number 2, we already named this, guys, whether identification poses a risk of retaliatory, physical, or mental harm to the party seeking to proceed anonymously, or even more critically, to innocent non-parties. So I don't know if this judge is just swayed already by what's going on in the Texas courts as well against JayZ and Roc Nation regarding this matter. Let's go to number 4, whether the plaintiff is particularly vulnerable to the possible harms of disclosure, particularly in light of her age, okay? The plaintiff was 13 years old, allegedly, at the time, and the plaintiff is autistic, okay? So let's talk about it. And number 7, whether the plaintiff's identity has thus far been kept confidential. And so far, the plaintiff's identity has been kept confidential. So it looks like the judge is using those 4 reasons, okay? So it says factors 1, 2, 4, and 7 weigh strongly in favor of anonymity. In her amended complaint, plaintiff alleges that defendants drugged and R-worded her when she was only 13 years old, okay? And as we talked about the other day with the case law that Buzbee had pointed forward in regards to the child that was R-worded with the archdiocese, and that he had come forward with that, that was a very strong case law that he used, where they found that this particular defendant or this particular plaintiff would not necessarily remember all the dates and times and everything that should have happened. As a matter of fact, they gave him and everyone else a 4-year period in between that, okay? So that it might have happened, if it happened in 2020, it might have happened in 2024. If it happened in 2010, it might have happened in 2014, but they have that window of time, right? Where these things might have actually taken place. Okay. And that generally comes out with most people that have been abused and that come out and talk about that as an adult. Okay. Now it says, and then it just gave some compelling information regarding that. And then it says, courts in this district have recognized these allegations concerning sexual assault are highly sensitive and of an extreme personal nature, okay? And then she gave some case law regarding this, okay? There were several case laws that she gave regarding this. Doe versus Skyline Autos. We have Doe versus Indike. We have Doe versus Towns. So she gave several case laws in regards to this. And these are recent case laws as well. One of them was in 2019. The other one was actually in September 2024. And the other one was in May of 2020, okay? Plaintiff is particularly vulnerable to these possible harms of disclosure. Sealed plaintiff 537 F3D at 190. According to her amended complaint, she continues to experience depression, post-traumatic stress disorder, and a seizure disorder associated with the stress of her assault. Okay. And then she talks about how the case law of Indicate 2024. And then she says denying disclosure in part because of risk is posed to plaintiff's already fragile mental health. Moreover, plaintiff's counsel asserts that many of his other clients who have filed similar lawsuits against Sean Combs claims to have been threatened by Mr. Combs for their decision to speak out. Okay, and this is in EFC number 33, 5, and 6. And finally, although plaintiff sat for an interview with NBC News concerning her case, NBC allowed her to conduct the interview anonymously, and that's in ECF number 46, verse 1 through 5. Granted, several factors weigh against allowing plaintiff to proceed anonymously. Plaintiff is challenging the actions of private parties, not the government. And given the media attention surrounding the case, the public has a substantial interest in this litigation, separate and apart from its general interest in an accused being able to publicly confront an accuser. And that would be Doe versus Combs, number 23, civil. This is the number. Okay, this is the within the Combs case. Alternatively, mechanisms may exist to protect confidentiality, namely the redaction and sealing of documents. See Skyline Autos 375F, and this is the case number. Most importantly, plaintiff's continued anonymity may cause prejudice to defendants, making it more difficult for them to collect the facts necessary to mount a defense and, as appropriate, challenge plaintiff's credibility. And this would be Combs here, identifying the most significant form of prejudice to defendants as the discovery disadvantage that plaintiff's anonymity would present. The court does not take such prejudice lightly. Okay, so she wants to be very, very fair with this situation. She definitely wants to not, weigh in and just take on Jane Doe's case and act like she just believes her. She has to be fair in this situation and say there are actual reasons for why the court can go against this, okay? And she's presenting those within case law. Nevertheless, at this exceedingly early stage in this case, the factors counseling against disclosure outweigh those that counsel favor. CF Doe versus Delta Airlines, and then she gave the case number for that, requiring the plaintiff to identify herself as the case to approach trial. Accordingly, plaintiff's motion to proceed anonymously is granted, okay? So even though she gave us the reasons why she could deny this, right? She actually weighed in to factor 4 different reasons for why she would actually take this in place. And so she gave Jane Doe her day in court. And she said, accordingly, plaintiff's motion is to proceed anonymously is granted. Plaintiff is advised that because the balance of these favors will certainly shift as this case proceeds, especially if and when the parties engage in discovery earnest, the court intends to revisit this decision at a future date. So there may be time where the judge says, you know what, I'm going to have to let her name come out, okay? Which I thought was going to end up happening eventually. Eventually at some point in this case, Jane Doe is going to have to come forward, right? Or may have to come forward in this case. I don't know for sure. The judge may, rule against it, but she may actually have to come forward in this case, okay? So the judge has ruled at this time that Jane Doe can definitely remain anonymous at this time. So that is a huge blow to JayZ's camp, okay? Now, let's go ahead and go forward with the remaining motions. Since Carter's attorney first appeared in this case 17 days ago, he has submitted a litany of letters and motions attempting to impugn the character of plaintiff's lawyer, many of them expounding on the purported urgency of this case. Okay, and then she gave the case number, EFC number 38 in the case, describing plaintiff's counsel as self-promoting and accusing him of extortion. Now, EFC 41 and 1 requesting to be heard on the expedited basis and accusing plaintiff's counsel of exploiting the legal process to generate media attention. Now, for those of y'all that don't know, Spiro is actually trying to file a case against Buzbee for defamation, okay, which I found to be outrageous, okay, Absolutely outrageous. The reason why is because that kind of like goes against the whole attorney-client privilege, right? Like if I hire an attorney and I present evidence to my attorney that my attorney now believes my story and now takes on my story and then files a suit against me. I mean, isn't that how the law goes, right? I mean, I'm not sure how that would be defamation on his part if he's simply believing what his client is telling him, right? If his client is telling him, this happened to me and I want you to represent me, here is the evidence and here is the money, I'm not really sure how that, turns into defamation. Because if that's really the case, right, then I guess, Buzbee can then turn around and sue Spiro for the same thing, right? Because Spiro believes his client, right? He believes that Sean Carter is saying he's not lying. Sean Carter has given him some kind of evidence to prove he's not lying. Sean Carter has paid him the money to believe he's not lying. And so therefore he's doing his job, right? He's going to the court. He's filing these cases. And I don't know how that falls under defamation, but yet Alex Spiro filed a case against Buzbee for that. So, I'm looking to see what actually happens with that, right? But I definitely think he opened a can of worms when that happened, because that kind of opens the case for any attorney to be sued, if, they're representing their client and they're believing their client based off of evidence that has been presented to them. I'm not sure how that becomes defamation, right? But we'll see how far this goes. Now, it says, let's just go back a little bit. It says, since Carter's attorney first appeared in the case 17 days ago, he has submitted a litany of letters and motions attempting to impugn the character of plaintiff's lawyer, of many of them expounding on the purported urgency of this case, okay? And then it talks about him being self-promoting, accuses him of extortion, all kinds of stuff, okay? Requesting to be heard on an expedient basis and accusing plaintiff's counsel of exploiting the legal process to generate media attention. And then she gave EFC number 42, one, asserting that plaintiff's counsel seeks only to benefit himself, which is what Spiro's been saying, okay? EFC number 46.3, requesting the shortening of the deadline from 21 days to 1 day, which I found crazy, okay? EFC number 48 at 11.15, describing plaintiff's counsel as willing to blatantly violate the core ethical obligations of the attorneys and requesting a hearing on a motion the following day, okay? Carter's lawyer relentless file of combative motions containing inflammatory language and ad hominem attacks is inappropriate, a waste of judicial resources, and a tactic unlikely to benefit his client. Didn't I tell y'all that's the other day? Didn't I tell y'all the other day, the way that Alex Spiro is moving looks crazy, right? Like it's out of pocket, it's out of line, and it's making JayZ look guilty, okay? It's making him look really bad with the way that he's moving. And the judge obviously agrees with me. The court will not fast track the judicial process merely because counsel demands it, okay? So which is what I said the other day as well, how JayZ is so used to, people just being yes men to him and people just jumping up and going with whatever he says, that his lawyer gave him this idea that he would make this happen. And the judge is like, you crazy. Like, you done lost your mind, okay? No, we are not going to do this, okay? And it's definitely not benefiting, JayZ at all. So now she continues to say, moreover, although Carter's attorney assails plaintiff's lawyer as having a chronic inability to follow the rules in EFC number 48 at 3, Carter's counsel has failed to abide by this court's clear rules. Under the court's individual practices in civil cases, and with limited exceptions, a pre-motion letter is required prior to the following of any motion, okay? Although Carter's attorney stated that he intended to file immediately a motion to strike the first amended complaint under Rule 12F, EFC number 46.3, he did not give plaintiff the requisite 5 business days to respond. And you can see individual practices there. And wait for the court to set a motion schedule, okay? or state whether any exception to the court's individual practices applied. Okay. So again, like I said, the stuff that Spiro has been doing has been looking like he's been doing this for the public's view, right? Trying to, shake up the public, trying to shake up any, any jury that will come up in the future and so forth and so on. I'm not saying that he actually did that, but that's the way it looks, okay? Just based off of all this crazy stuff that he's been trying to force and demand the court to do, as if the court is really going to listen to him, right? And it's funny because I think Alex Spiro knows this. I just think that, he's willing to take the thousands and hundreds upon thousands and millions of dollars that JayZ is willing to pay him and, make JayZ believe anything he wants him to believe, right? That's what I'm thinking is going on. But what he's ended up doing is hurting JayZ in the process, okay? And making him look pretty freaking guilty, especially when a judge is coming out with this, okay? She says, this is unacceptable. And then we're going to go to the footnote. She said, on the merits, Carter's motion to strike is denied. Motions to strike under Rule 12 are generally disfavored and will be granted only if there is strong reason to do so. And she gave some case law in regard to that. Carter's motion, which summarily asserts that plaintiff's claims are baseless and salacious, does not clear that high bar at all, okay? Now, like she said, that is a very high bar to reach. And the BS that Spiro has been trying to spill to the news stations and to the public and all this stuff, it is not running with the courts whatsoever. She is going to go by her job, okay? She don't care about JayZ, his friends, or none of that stuff, okay? She cares about the law, and she's sworn to this, and this is what she's going to do. And obviously, she cannot be bought, okay? So now let's go ahead and keep going. Let's go ahead and keep going. It says, and wait for the court to set these things. Now it says, it is unacceptable. Counsel is hereby advised that any further motions filed in violation of court's individual practices may be denied on that ground alone. Period, Pooh. Okay, so she let Alex know you need to have several seats, sir. Okay, what you're not going to do is come in my courtroom and tell me what I'm going to do because JayZ is your client. I really don't care about Sean Carter, Beyonce, none of them. They don't tell me what to do. Okay, and that's what happened. Okay, lastly, although Carter's attorney is entitled to file a Rule 11 motion without first seeking leave of court, see Individual Practices 3A, the court discourages this approach. If he still intends to serve plaintiff with a motion for sanctions, the court denies his request to shorten the safe harbor provision contained within Rule 11C from 21 days to 1 day. So she was like, nope, we ain't doing that, okay? Carter's motion to strike the amended complaint under Rule 12F is also denied, okay? By January 10th, 2025, the plaintiff shall file her response to Carter's motion for an order directing the preservation of evidence. So she definitely is not allowing any evidence to be destroyed. She definitely wants all of that to come forward, and she's making that a rule by January 10th, which is what, 15 days from now, if even that, right? And by January 17th, Carter shall file his reply, if any, okay? So all this stuff about 1 day, tomorrow, judge, you better do this, and all that stuff, she told Alex Spiro, you and all your team, you, Beyonce, all of y'all need to have several seats in my courtroom, and that's it. And it is so ordered December 26th in New York, by Annalise Torres. So I thought that was quite interesting, okay? And I thought that was a great thing that has happened at this point. Y'all make sure y'all let me know what y'all think in the comment section. But I think this was definitely a huge blow to the Carter family. I don't think that he's going to make it in this situation. I think that he has the wrong attorney representing him. And I think at this point, he might want to think about, grabbing somebody else up who's going to go at this in a much better way than Alex Spiro and his team have done. because it's obvious that he is not helping JayZ at all. I'm going to go over y'all comments real quick, and then I'm going to actually end the show. Do appreciate all of you for being in the building. Hey, Redbone and Carla Martin, definitely appreciate you guys. Hey, beautiful, appreciate you being in the building as well. Child, this is very crazy. This is very, very crazy. You said, oh, she can go forward anonymously depending on the charge. Exactly. And it looks like the judge was in absolute agreement in regards to that, and that she is willing to allow her to. And she gave 4 provisions for why. And there's only 10 provisions for why somebody can. We already talked about one of those provisions, and it turns out that she's using that actual provision. So that's just one of them. Yes, child, this is crazy. Hey, YouTube Unfolded, definitely appreciate you being in the building. You said, NGL, it's hard for me to keep with. Thank you, Miss T. Pre. No problem at all. Y'all know I'm going to bring y'all this hot tea, and I'm going to continue to do that throughout 2025. I know there's going to be a lot more coming up in this case, along with the Diddy case. I plan on covering all of that for 2025. I plan on covering everybody that's going to be revealed in 2025 as well. So we are going to be talking about these celebrity hot topics. We got Pacer on deck, okay, and just ready to see what's actually going on in these cases. You said, it seems like Spiro jumped out the window. I said that the other day. I was like, yo, he's really moving crazy. Just kind of just jumping the gun and saying a bunch of stuff. And this judge is like, all of y'all need to have several seats. I don't know who y'all is, okay? But I am not to be bought. That's not what we doing out here. Hey, Teresa, appreciate you being in the building, sis. You said that makes that F-ish worse, okay? You said, so that gives a longer span of time. This is going forward. Hold on, guys. Hold on. Okay, you said, so that gives a longer span of time. This is going forward. Exactly. Yes, she will have her day in court, and they are not going to take that from her. And it just is what it is. Hey, Steph, I appreciate you being in the building. You said, I'll be in the clouds for a minute. No problem. I'm actually going to end the show. But thank you for coming in. I know that you will definitely look at this and see what's up with it. And I appreciate you. And every other attorney that has been hitting me up behind the scenes, telling me stuff about this, I appreciate all of y'all as well. You said, hey, Miss T-Pre. Hey, beautiful Bernice. Definitely appreciate you. You said, TVB, I hope you're enjoying this holiday break. I definitely hope everybody enjoyed their Christmas break. Make a change. Definitely appreciate you for being in the building as well. And everybody's just saying hey to each other. And hello, Luxy 3. I don't know what that is. You said it's never defamation if proven to be true. Well, yeah, so it has to be proven to be true. But unfortunately, I don't know why he kept saying, and he's trying to sue this guy and going through all this stuff. It's like I said, it's like he's doing this for public opinion in regards to, what the public thinks, trying to sway the jury in the future and so forth and so on, as opposed to just going about this the right way. And knowing that the judge is not going to go with all that, but we'll see, right? And obviously, she letting him know she ain't the one. He said also has to be proven that defamer suffers from loss of business and social decline, etc. Also, people have freedom of speech exactly. Are like this public for every content creator. Yep, and that's the very truth, right? There's a very big difference in defamation and speaking your opinion about something. Speaking an opinion is not, that's actually protected under your First Amendment rights. But when it talks about, defaming somebody's character and actually spilling out lies on purpose about somebody's life, and, without having actual evidence of these things, speaking it to a large group of people, and that actually affects, your character, then absolutely that is defamation, right? That is not the same thing as what's going on here with attorney-client privilege, where an attorney is taking on a case. They've vetted some information from their client. They believe their client, and now they're presenting this to the court. That is not the same as defamation. I'm sorry. And I know Alex Spiro knows this. This is why the judge is probably just looking at him crazy right now, right? Like, are you crazy? Have you lost your mind? What's up, Gaber Yahoo? I appreciate you being in the building. And Tender Catering, you said, I'm new here. I love your content. Thank you so much. I appreciate all the new subscribers that have come out lately. And Skunk Freaker, I appreciate you being in the building. One of my favorites. You said just dropped in now. I'll catch the replay. Loving the Diddy and JayZ content. No problem. And I always appreciate you and everybody that comes out and everybody that catches the replays. Make sure you guys are hitting the like button on the way out. And guys, we are out of here. I appreciate you guys. And you guys have a wonderful new year if I don't talk to you before that. But we are going to be on this case and definitely following this situation. So if anything happens between now and then, I will definitely be back up here to let you guys know. And peace, guys. Thank y'all again for watching.